Experience with this. This is the Kitsap Sun's editorial board course, and we're talking to Kitsap County Prosecutor Russ Hauge, who's running for re-election. Russ will give you 2 minutes to introduce yourself, and then we'll go into some questions.
Sure. Thank you for doing this. As I was telling you out there in the front, it's really a pleasure to talk with people who are, by definition, informed, and in my experience, informed, and who are actually interested in the issues. And I think that if you focus on the issues, you will see that one more term for me would be the best course of action for Kitsap County. Have you read my annual reports at all? Every year we publish a report that details our performance, our initiatives, tries to give some performance measures of our office. If you look at the reports filed by other prosecutors' offices, I think you will compare this favorably to those. Over time, we've included less data because, quite frankly, people seem to be less interested in that. I know when we first started doing it in 1995, I would get calls from the Sun staff, when's it going to come out? That hasn't happened much, but it's out there. And my point is that the way we do business is transparent. We occupy a key position in the criminal justice public safety system. The police do the hard work of patrolling and arresting and building cases. We're the ones who have to decide whether those cases go forward. In Washington, we don't utilize the grand jury. It is the prosecutor's decision, and the prosecutor's decision alone, that takes a case forward to a judge to determine whether there's probable cause to proceed and whether the case will go to trial. And in Kitsap County, just like the rest of the country, 95+% of all cases result in guilty pleas. That is primarily because people are guilty and that there's no real reason for them to go to trial. I have developed over 20 years, I've been in this job, very effective partnerships with the other players in the system. My campaign co-chairs are Chief Al Townsend from Paulsbo, Chief Jeff Martai from Port Orchard, and Steve Strand from Bremerton. Matt Hamner was on the committee until he found out his new employment contract didn't allow him to do that.
2 minutes.
All right.
Plus. No, go ahead, wrap it up. Go ahead, wrap your thought.
Well, at any rate, in addition to the support of the local law enforcement committee or community, I also have the support, or not the support, but the trust of the other 38 prosecuting attorneys. Since 1997, I've been their legislative chair. That means I'm effectively their lobbyist. I've been involved in some legislative initiatives on behalf of the prosecutors that I'm very proud of. I'd like to talk with you about. I also represent the Prosecutors Association on the Sentencing Guidelines Commission, the Washington Partnership Council for Juvenile Justice. I'm our delegate to the State Supreme Court Minority and Justice Commission, and I was just appointed to the Justice Reinvestment Initiative Committee appointed by Governor Inslee by executive order. We're going to be looking at the question of whether we need to build another 1,000-bed prison or if we can find some other way to deal with our issues of adult felons incarcerated currently. In short, I operate transparently. I have a record. I have the trust of the people that I work with.
Let me follow up just on one thing that you said. First, you said one more term would be the best thing for Kitsap County. Is that because you only think one in the future, or?
No, I'm not making any problem, but I'll be 67 at the end of another term. And quite frankly, I didn't get into this job to be a politician. I told my wife on our first date I was going to do this. She signed up for one go-around. We've done that, and now 2 more. So I don't know if I could talk her into it again if I'm willing. No, I'm not. I do not have plans to stop at the end of this term. Although, realistically speaking, I'm getting to an age where it's time to consider someone else doing the job.
Okay. And the second question is: you said maybe the best thing for Kitsap County. when you try to put that in terms of real issues, real statements, real action, what's at the top of that priority list?
Okay. We have first off, in Kitsap County, we have a tradition compared to other counties where the people responsible, well, just for local government generally, work together very well compared to many other counties I could name. In the justice system, among the cities and the county, my office, we work together very closely and very well. A lot of the initiatives we've been able to put together have been on the basis of that. As you know, we do the municipal court prosecution via contract in 3 of the 4 cities. And that is very rare. We were asked to do that by the cities. It makes financial sense for them, and it also allows the same consistent application of standards throughout the county that we apply in the district court. So we also know about the people who are being prosecuted in the Port Orchard Municipal Court, the Grand Regina Municipal Court. In addition, every initiative we undertake, whether it's domestic violence, whether it's human trafficking, whether it's drug sentencing reform, relies on the actions not just of other police agencies, but the city councils and the county commissioners, because they're the funding agencies. We have to work together. And that is, I think, something I can say without false modesty that I've done pretty well. I've established a level of trust with those other decision makers that allows us to innovate, to reach out, and when we see a problem that needs addressing, like human trafficking, the city of Bremerton, the city of Paulsbo, and the city of Port Orchard, who have now joined the Special Operations Group, are all on board with that as well, and we're applying the same standards, we're applying the same strategies to deal with that. A really good example is the Special Assault Investigation and Victim Services Board, SAVES. You might have heard of that. We have 19 different agencies all involved in providing services of one kind or another to the people who find themselves involved in sexual assaults or domestic violence. From CPS to the tribes to the other social welfare agencies, the YWCA, and we all work together. We have a nonprofit corporation, a board, and we develop policy. The SAVES protocol is a model that's followed by a lot of other jurisdictions in the state. And it allows us to take a uniform approach to minimize the trauma on the victims of sexual assault. It's that legacy of cooperation and innovation, quite frankly, that I am most concerned about if I'm not allowed to continue in this job.
How common is it for a county prosecuting office to do the municipal work on a contract like that?
Very rare is my understanding.
How do you make sure it doesn't take away from doing kind of the primary county specific stuff?
Because they pay for it and we use that money to hire extra people.
It makes things bigger.
Right. Yes.
There's, you brought up the sexual assault and domestic violence. There's a couple other kind of themes that have been in our reporting a lot lately, and I was very quickly kind of what your office has done on these issues and what you think the prosecutor's role is in each of those. And that would be, we're seeing drug use, particularly heroin use.
Yes.
We've been reporting on that quite a bit. Mental illness and how that infiltrates the criminal justice system. And then an issue that I know Steve Strand talks about this the most often, but it's focusing on what they call frequent flyers or repeat offenders. And
Right.
so I'd like your opinion on those 3 things, kind of briefly, how you, maybe in your seat right now, have tried to do these, what's worked, and what you see the prosecutor's role in each of them.
Heroin first. It has been in the last 5 years that we've seen a real influx of heroin. Before that, on the daily in custody list, if we saw a heroin case, it was cause for remark. We just didn't, it was not something we ever saw. Now, I think 42%, 45%, almost half of the people we have in our felony drug court are there for heroin, and it's on the in custody list every day. And it's hit the rest of the country at the same time. The reason is that the opiates that were being abused, prescription opiates, were reformulated so that they could not be smoked or snorted or shot up. Right there, available as a substitute, was black tar heroin in our part of the country, white powder on the East Coast and in Canada. What I have done particularly, what I think my role is, to try to fold whatever efforts we can make to specifically target that problem into the rest of the drug interdiction regime that we put together. For example, we have we have a law and justice council like every other county. I've been the chair for years. We don't meet regularly because we don't have meetings just to have meetings. We had a meeting because of heroin. It hit really hard in Paulsbo. The mayor was concerned, the health district was concerned, so we brought the council together. We started talking about what we can do. Well, the step that we revealed was medication-assisted therapy for heroin. Unlike methamphetamine, there are a range of medications that can help control the craving. The object is not to cure someone of their addiction by giving them another pill or other drugs, but it does allow them to focus on the treatment that is the same treatment that we use for methamphetamine or other substances fairly successfully without relapsing. We're going to have another meeting of the Law and Justice. We had a first meeting to talk about the dimensions of the issue, second meeting to talk about what really medication-assisted therapy looks like now, because there's been considerable changes over the last 4 or 5 years. Back when we were talking about methadone clinics as really the only option. And the meeting we're going to have on August 1st, we're going to talk about how the steps we've taken further there. What I just learned from Judge Roof today was that the drug court is going to cooperate with the Squamish tribe, which has been utilizing medication-assisted therapy, try to fold their resources into the constellation of resources that are available through our drug court here.
That therapy is different than a methadone clinic?
Yes, yes. There are 3 drugs. Methadone, which requires administration in a clinical setting. Then there's Suboxone, which can be actually prescribed and taken home by someone. Then there's a new drug called Vivitrol that can only be that can be used on a monthly basis, injectable. I don't know that much about that one. But at any rate, there's news on the front, and it's the prosecutor's role, because we're in the middle of everything, because no case goes forward unless we hear about it, because we're responsible for making sure the sentences are actually enforced. We're the natural leaders, so that's what we've been doing there. Next, you asked about mental health, and it's the same dynamic. We're in the middle of everything. In Kitsap County, we have a law firm of about 100. There are, depending on how you count the interns, about 50 lawyers, about 50 support staff. And so I'm primarily an administrator. It doesn't make sense for me to carry a caseload. I have to assign somebody else to do the work. And if you want, we can talk more about that later. But the thing I do insist on doing myself is the reviews of the officer-involved shootings. Because those are traumatic events for the entire community. And I want, when we issue our opinion, there to be no question but that it's the opinion of the responsible elected official. So I do that work. Over the years, what I have seen is first an increasing frequency, And second, that the victims, if you will, the mentally ill person or the person getting shot is generally mentally ill. The Summermeyer case that we had here in Bremerton this last summer was a classic case. A woman was on KMH's caseload. She'd been contacted 15 times over 5 years, and everybody knew what was going to happen. The police bear the primary responsibility for intervening when somebody's in crisis, and literally the only tools that we give them or have been giving them are their guns. And that's just not right. So again, what we've been doing through the Sheriff and Police Chiefs Association, I'm not the leader, but we're all working together on this. We've put together, we're trying to put together a variety of ways to address this. First off, Bainbridge Island has led the way by making all of their street officers qualified as crisis intervention officers. They've all gone through the 40-hour training curriculum at the Criminal Justice Training Center. Every department now has at least one person who's gone through that, and they've developed a cadre of what they're calling crisis intervention teams, CIT officers. And again, striking that theme of cooperation, they're making themselves available across jurisdictional lines when a mentally ill person is in crisis and it looks like it could turn into a violent situation. So we've been helping with that, assisting with that, supporting with that however we can. We also put together a proposal for the one physical non-personnel piece that really needs to happen is we need to develop a place to take somebody who's in crisis that is not jail and is not the emergency room. Unfortunately, the facility that we currently have on the drawing board, the Sheriff and Chief's team went from cold start with KMH to completed grant project in about 6 months, really a good piece of work. But still, it's going to cost about $3 million. And the revenue stream from the mid-tax is about $3 million. Is not all going to be spent there. But the commissioners did block some off. We're working on developing that facility. We also, I think, have opportunities that we haven't explored. They need a facility like that, but we hear lots of talk about mental health courts. And it's a really undefined term. But in general, what it means is we have a mentally ill person who runs afoul of the law. The police are called. The police make an arrest. The mentally ill person is probably booked in jail. They're charged. They're brought before a judge. Then they're referred to a mental health court, which means that a judge, like a drug court, sees them regularly and ensures that they comply with the conditions of treatment, which most of the time are just taking medication. And unlike heroin, for example, where you need a treatment regimen in addition to your medication-assisted therapy, the naloxone or whatever you're taking, a lot of very, very seriously mentally ill people, once they take their medication, they don't need anything else. They need support in the community, but they don't need a formal treatment regime. There's no AA or something like that they have to go through, or intensive outpatient treatment. So there's a provision on the books that I'm not sure has been used. It's been, I picked it up quite frankly because there's been some talk about it on the WAPA line about a pre-diversion program where the police, the prosecutor's office get together with the local mental health provider, develop some criteria so that when we have somebody like Mrs. Summermeyer, who ended up getting shot, maybe in one of her prior contacts with law enforcement before she came at them with knives, if she fit the criteria, the police would then, following guidelines that have been established in conjunction with us, because we make the charging decision, they put her in touch with services with the understanding that if she continues on with those services, takes her medications, she avoids any charge at all. Provides some incentive. A lot of holes to fill, but I think that's the way to go rather than the classic mental health court, because it's much, much closer to the problem. And that's really what we need. We need to get it involved fast. And it does a mentally ill person no good at all. it does them harm to put them in jail, does them harm to put them in the emergency room where they don't need it, and if you're mentally ill, you are by definition not responsible for your actions. I think it's a misapplication of the criminal law.
Is this idea far enough along so that maybe next year it could be in that list of applicants for the mental health tax funding?
Yes, I think it's far enough along for that. We're going to be discussing it at the meeting on August 1st. My hope is that maybe we can find a way to cut down on the financial impact of the facility that's currently proposed. If the statute talks about in terms of a 12-hour stay instead of up to a 5-day stay. I'm not sure if that's really practical. As far as I know, this hasn't been used, but I think there's some, and that money's the big issue. There is, I think, a possibility that we could create something along those lines.
And so are you saying that idea could come back before that board at a lower cost?
Yeah,
because that was one of the concerns.
That would be my, yes, that is my hope.
Okay.
It's early days, but I think that there is at least the seed there for something that will fill the same gap but cost less money.
And then repeat offenders.
Yes. The reason that we have now a Justice Reinvestment Initiative, the Pew Foundation, coming to the state of Washington to look at the question of whether we need to build a new prison is because of repeat offenders. We are in a way the victim of our own success. As you may know, Washington's Sentencing Reform Act was on the cutting edge of felony sentencing when it was adopted in 1982 and took effect in 1984. And what it does is say that lower level offenders, depending on the seriousness level of your crime, which is measured on the up and down axis, and their criminal history, which is measured on the right to left axis, you go to jail for a period of 3 to 9 months. If you get another felony conviction, it's 6 to 9 on up. What we're seeing now is that as our population matures, that we're seeing people with longer criminal histories being sentenced. Now, we have a 3 strikes law which allows us to incapacitate, that is put into prison for the rest of their natural lives, a subset of people who would not otherwise go there because they haven't committed serious enough crimes. The list in Washington is very short compared to what it is in California. They are all crimes against persons. There are no drug crimes there, but still you can end up facing life in prison for robbery in the 2nd degree, not just aggravated 1st degree murder. That's used very sparingly because locking somebody up forever is very expensive. The Sentencing Reform Act limits our discretion in terms of what kind of sentence we can ask for. So, in effect, I guess what I'm trying to say is that we would expect to see more frequent flyers going to prison for longer periods of time. That's the way the Sentencing Reform Act is supposed to work. In terms where we've dropped the ball, where we are creating or maybe not doing all we can to prevent that person from reoffending, is in reentry services. One of the first casualties of the big financial crunch that we went through was programming in the prison system. Right now, the Department of Corrections takes the position that if you're there for a long time, you're not going to get any programming to help you when you get out until the very end of your sentence. So in the old days, you could go to school, you could take vocational classes, there were work opportunities. Those are all gone. So what we have is a situation where long-time incarcerated people are coming out without a lot of resources, sometimes with untreated substance abuse issues, and they immediately reoffend. the way Washington has set it up, it's primarily a state issue in terms of the funding for these reentry programs. However, the Prosecutors Association, which I'm a member, I'm their legislative chair, has been paying very close attention to this, and we would very much like to see some dollars restored to the department so that we have a higher degree of confidence when somebody gets out, they're going to have the tools to succeed. They're not going to have to go rob somebody else to stay.
Is this only programs within DOC or also supervision programs?
The DOC runs all supervision
Right.
for felons.
But the money you're talking about that the prosecutors group is asking for, is that for the types of classes and formats that would go on prior to release, or does it need to be?
There is almost no supervision
Almost
for
nothing.
anyone prior or after release or prior to release. And,
It's
about the only-
it's equally as bad.
pardon me?
Equally as bad. Both of them are underfunded.
Right,
Okay.
right. We've cut back dramatically on what you could call parole services. Somebody's in the community, they have a community corrections officer, but they are not going to be on active supervision unless they are very dangerous. The run-of-the-mill property offender, the person who is the 10 or 11 or 12-time burglar, is not going to be supervised probably when he gets out in the community. He's not going to be supervised very closely because the decision has been made to spend the resources on supervising violent offenders and sex offenders. And the programming in the prison before they get out has been cut back so that, again, they come out with very few tools. But the only thing we do have is the last period of months incarceration can be spent in work release. We have a work release facility in Port Orchard, and I'm on the board of that facility. They do a good job, but the jobs they get people can make a difference. It's much better than putting people out without any kind of transition, but it's not very much. And the other thing is, even if you've got someone who is highly motivated when they get out of prison to get a job, move on with their lives, the stigma of the conviction follows them around. There are a couple of things there. In the juvenile realm, there's been some legislative changes that the Prosecutors Association supported, I testified in support of, to take steps to more efficiently seal juvenile records. And then there is an initiative that started last year, will continue to create what's called a CROP, Certificate of Rehabilitation something, CROP is the acronym, so that a person who is out of prison can say, no, I haven't fully paid all my restitution, but I am in compliance with all of my obligations. So employer or apartment renter, I am somebody that you can take a risk on. We're supporting that. And again, it's because if we don't support things like that, we see them again.
When you say you're supporting it, just in support, or do you actually have involvement in it? Does your office have any involvement at all in that?
I will have personal involvement in it. I will testify in favor of it. I haven't testified in favor of it in front of the relevant legislative committees.
Okay, but there's no physical involvement, no paperwork that you do?
No.
to maintain that?
It's a legislative
Okay.
proposal.
Knowing the kind of the issue you're talking about with DOC supervision and things like that, has that, because that's an ongoing thing, it's been here for a couple of years now, has that changed your charging policy at all? Does it change how you think about when a felon reoffends and what your office will charge? Because you know there's kind of a community reaction when they hear, this guy's done this a few times.
Not really, because we have, our charging policies have been applied pretty consistently. The big issue for us is whether the person is going to accept responsibility, because that gives us at least some sense that maybe they want to turn it around. We will take chances on people in drug court. We put a lot of people in drug court who are facing prison sentences of 5 to 10 years. Keeping them in the community because Generally, they're older and they're tired and they want to get better, and we have had pretty good success with that. There are people that we come across that we know are going to offend again, period. And generally, those people, we will start, our policies say that we generally are conservative in adding enhancements or the other multipliers that are available to us. Those are the people we will load up, because we know that literally the only thing we can do with them is keep them locked up for as long a time as is possible. So, but I don't think our policies have actually changed. We've pretty much always done that.
This is a good segue to one of the questions we asked on our election guide about the felony early plea unit.
Yes.
Give us a brief description of what that is and why it's something you're in favor of using it as county. It's my understanding that we're pretty unique in using it here.
Yeah. The felony early plea unit is a way for us to, within the law as established by the Supreme Court, and it's important to understand that we have several sources of law. There are, of course, the acts of the legislature, then the decisions of the courts have the force of law. But in Washington, our Supreme Court has been very active in rulemaking. And those rules have the full force and effect of law, and they guide us, control us in all of our procedural efforts. So, for example, you have a constitutional right to speedy trial. That is done on a case-by-case basis if you're in front of the U.S. Supreme Court or in most states. However, in Washington, they've established a court rule, doesn't have the force of constitutional law, but a court rule that says that if you are locked up for a felony, you will be brought to trial within 60 days or the case will be dismissed. If you are not locked up, if the case isn't brought to trial within 90 days, the case will be dismissed. That can, as you might imagine, create a lot of gamesmanship. It's not very much time, and very, very, very few, less than 1% of cases actually go out in the 60 or 90 days. Somebody always asks for a continuance, usually the defense. Sometimes we do, but usually it's the defense. So, but the key thing is when we start a charge, when we file a charge, we start clock running. And we theoretically have to be ready to try that case at the time we file the charge, because 60 days isn't very long. All right, so that takes a lot of work. The other thing that we know is that 95+% of all cases across the country in every jurisdiction result in guilty pleas. And that's because people are guilty and there's no benefit to them to go to trial. Particularly in a state like Washington, where the legislature determines what your sentence is going to be. So, looking at the rules, like a lawyer, we came up with the idea of doing the following. When we start a case in Superior Court, the judge is obligated not just to see to the probable cause supporting the case and whether the defendant's rights have been protected. It's all, the judge also has to make sure that case goes out in that 60 or 90 days. So they set hearings on status. We have what's called an omnibus hearing described in court rule. We have a rule 3.5 that says you must test the admissibility of all the statements. 3.6, you must test the admissibility of all the seized evidence. All these hearings get set. And they create a lot, you know, we have to go to these hearings because the judge sets a hearing, you've got to go to the hearing. So what was happening is, even though we knew that 90+% were going to plead guilty, we were starting them in Superior Court, we're setting all these hearings, we're going to 3, 4, 5, 6, 7 hearings before we got to where most cases get the plea of guilt. And it wasted a lot of time. What the rules also provide, though, is we can file the same charge, a felony charge, in the district court, the court of limited jurisdiction. And the district court can only concern itself with whether there's probable cause to support the charge and whether the defendant has been fully advised of his or her rights and whether appropriate bail is set. That's all. Now, in 30 days, the case can be either, has to be either bound over to the Superior Court, or it can be kept on the agreement of the parties in the district court. So what we thought was, if we got the cooperation of the district court, public defenders, we could create a period of time when, instead of worrying about all these other hearings that start out in Superior Court, we would have a period of time when all we had to worry about was whether we understood the case, which is difficult for us because, again, we are under time pressures to file. So if somebody's locked up in jail, we've got to file within 72 hours or else they go free. We don't always know everything. The defense doesn't know everything. We try to get them the information as soon as possible. The defendant needs to know everything. And what was happening in Superior Court with all of these hearings, the defendant was kind of being left out. They would show up in the courtroom, but they wouldn't get a chance to talk to their lawyer. So what we've done by creating this period of time in the district court with little pressure other than just figuring out where we are with the case is cut in half the number of cases that we have to put on this multi-hearing track in Superior Court. Two things have happened. We have cut the number, well, three things have happened. We have cut the number of cases we actually set for trial in half. We're still trying the same number of cases. In fact, we're trying more cases. We tried more cases last year, both in terms of the absolute number of trial days than we did the year before. And we also have freed up Superior Court resources so that they were able to do away with an entire calendar. I was talking to a friend of mine in private practice, used to work for me, been in private practice now for about 10 years. He said that he had 2 civil cases go out last year. And they both went out on the day that they were originally set. He walked down the hallway and told his senior partner, who's been in practice for 35 years like me, and he blew coffee out his nose. He'd never heard of such a thing. Because when I was in private practice, well, the sewer case that I did for the West Hills Association, we got a trial date 4 years in the future. And then when the trial date came around, we were prepared to get bumped by a criminal case which take priority. So we're creating room for divorces, for contract cases, for others to go out. Now, here's graphically, here's how it looks. This is the top chart is what you want to look at. And you can see that the number of trials has been cut in half, because what happens is, instead of setting the matter for trial, we just bring it up and we set it for plea entry. So we have 1 or 2 hearings. Now, I know there have been a couple of objections. Ms. Robinson has said that I'm wrong, that cases were resolved in the first or second hearing in her practice. Well, most of her practice has been under this regime. She's had a relatively small period of time in practice prior to we started doing this, so she's not really in a position to, I think, give that opinion, but it's her opinion. But certainly our lawyers all understand that it's created a tremendous amount of room for us. The other thing is, the other objection is that we're setting ourselves up for litigation down the road, that we're violating some constitutional rights. Well, again, the constitutional right for speedy trial is different than the right to speedy trial established in court rule. People in most states where they don't have speedy trial rules like this regularly spend a year or more in jail before they get to trial. And the Supreme Court says that's okay. That can still be a speedy trial. Washington leads the way. We have the most aggressive speedy trial that I know of in the country. And it's been suggested that somewhere down the road, this is going to come back and bite us. Well, we've been doing it for 4 years. Nobody's try to bite us. If somebody pleads guilty, they waive their right to appeal specifically, so they can't appeal it later. And the same rule that sets the time for trial, Criminal Rule 3.3, sub D, section 3, says that in those cases where we actually do, the half of the cases now where we do set a trial, if you don't object within 10 days of setting that trial date, you forever waive your objection. A party who objects to the date set upon the ground that it is not within the time limits prescribed in this rule must, within 10 days after the notice is mailed or otherwise given, move that the court set a trial within those time limits. A party who fails for any reason to make such a motion shall lose the right to object that a trial commenced on such a date is not within the time limits prescribed by this rule. And that's not just in here, that's in all the forms that we utilize to set trials. So everybody knows. Plus, everyone is represented by counsel. Nobody does this on their own. So I'm not worried about a time bomb out there where the Supreme Court's going to come in and say, oh my God, all the cases that you've done over the last 10 or 15 years or whatever, they have to go free. Because we thought about it beforehand. We wouldn't have done that if there was any substantial risk of that.
Let me ask about the case that has been going on for 15 years, the one that gets the headlines with Mr. Carter. There was recently, a district court judge wanted to return a weapon to him, and you're appealing that decision. Tell us why this is important to the community. Tell us why you continue to appeal that most recent decision.
Can I show you something?
Go ahead. Yeah.
I'd like to give you a little more background on that too. Came up today at the Exit Issues Forum, and there's some here.
We've never had AV at the Editorial board.
Now, this was done in 2008. My understanding is that it was redone because that's when we had video, digital video available. This is Kent Smith, Sheriff's Deputy out at the BPD Rifle Range. Can you hear it? Let's see if I can do this.
Serial number SP54419. The Colt AR-15 is the civilian version of the military M16. It's designed to fire as a semi-automatic rifle, meaning that when you pull the trigger, it will fire one round, and to make it fire again, you need to pull the trigger again. For the military M16, you can set it for either semi-automatic or full automatic, meaning when you pull the trigger in full automatic, it fires continuously until it runs out of ammunition. The demonstration today is to see whether or not this rifle will fire in semi-automatic as well as full automatic. In checking the selector switch on the side of the rifle, It does go into the safety position, it goes into the fire position, and it also goes into a third position toward the rear, which typically for an M16, the military version, that would list full automatic. On the civilian AR-15, there shouldn't be a third position. So at this time, I'll go ahead and load one magazine of 223 ammunition. This is a 30-round magazine, and we'll fire at the first few rounds at semi-automatic, and then I will move the selector switch to the back position, which appears it would be an automatic position. Currently, the rifle's in safe, and as I squeeze the trigger, nothing happens. I'll move the rifle selector switch to the fire position. It fires a single action, semi-automatic. Each trigger squeeze fires the rifle fire function one time. Now I'm going to move that selector switch to the back position. Rifle just jammed. I'll clear the rifle, I'll put it back. That was approximately 28 rounds with one jam. Put the rifle back in the safe position. Remove the magazine. Drop the charging handle. Render the rifle back
So the
safe.
owner
That
wants
concludes
it
the
back, that's what the
demonstration.
whole thing is going on about.
Yeah, there are two prongs to this. We charged the owner 15 years ago with possession of a machine gun. He had modified it two ways. One, with the SP1 and the early civilian versions of the M16, you could actually modify the weapon itself without the addition of extra parts to fire fully auto. He did that. He also created what's called an auto sear. I'm not really sure exactly what it does, except that it kind of slows down the rate of fire, makes it smoother, makes it less prone to jam. And these are his admissions. We tried to give it to the feds, federal crime as well. They didn't want it, it wasn't big enough for them. So we charged him. The story in broad outline is we'd bring for a local judge, they would dismiss short of trial. We'd go to the Court of Appeals, they order it back for trial. That happened a number of times. By the time we got to the point where we were really ready to try it, one of our witnesses had died. One was not competent to testify. One lived in another state. We dismissed the case, moved to forfeit the weapon because it's a machine gun. That is still pending. The judge originally ruled that it would go, well, we feared the way his ruling was written, it was a little obscure, it was going to go back, contacted the federal government, said, this is going to enter the stream of commerce again. Do you have anything you can do? They sent some of the ATF over, they analyzed it, submitted affidavits that it's a machine gun with or without the extra parts that were manufactured, and that it should be forfeited. And that's where we're at right now. The judge has yet to render a decision. Now, separate and apart from that, in 2010, I was approached by a group of citizens who lived near the rifle range. It was greatly expanded in operation, and we examined the case, tried to resolve the case, were not successful. We went to trial before a visiting judge in Pierce County and won everything. The judge's ruling was that the range had lost its status as grandfather, that it constituted a public nuisance, just basically everything we asked for, they gave us. We spent $86,000 of the county's money on that. If you take the time that the lawyer spent over the last 4 years on the case and multiply it by our hourly rate, $120, you get a big number. But that's not a number that means anything, because those lawyers were there on staff. They were doing work that they were supposed to be doing. The $86,000 for expert witness fees and mediation fees, things like that, are chargeable against the Rifle Club. It's on appeal now. We expect we'll be the prevailing party. We expect we'll get that money back because they're fully insured. The two have, all I can do is say it, the two have nothing to do with one another. Mr. Carter did a grand job representing himself, preventing the case under the machine gun from going to trial. That's the way it works, but before we give a machine gun back to a private citizen, I'm going to have a judge tell me to do it.
All right. We're running up against our time limit right now. We covered a lot of ground, but we'll give you just 1 minute to conclude, and anything that we didn't touch on, or anything you'd like to leave us with.
There's one document that talks about the felony early plea unit. This is as best we can come up with a transcript from Judge Laurie at last year's budget hearings, talking about the effect of the early plea unit on federal court practice, or rather the superior court practice, and the extra capacity that it created. Leave that with you.
I can share this with them.
Oh, absolutely, absolutely. Now, again, that came as a transcript that was privately done from the budget hearings. This is not to, I do not mean to imply that Judge Laurie is endorsing me, the program, or anything like that. It's just, this is what she said. It's part of the public record, and it corroborates what I said. Again, what I'd like to leave you with, that we really haven't touched on, is this. I'm part of this community. Yes, I hold a responsible position, but I also live here. The others live here as well. But if you look at my resume, and I've given you some of the things I've been involved with, I've been part of the fabric of this community through the institutions that make any community go, the charitable institutions. I work to make the bar more responsive and run better. This is my home. This is where I'm committed. I did not come to this lightly. I do not enjoy running for office. I love my work, and I will gladly run for office to do that. As you go forward, I ask you to look at the facts. A lot of things can be said about how, oh, he charges too light or he charges too heavy. Well, look at the facts, and you're in the best position of any to check that out. And remember, too, that I'm the one with the experience dealing with a large organization, an organization I built. Doesn't mean I'm the only one that can run it, but I know it, and nobody else does, at least not the other people who are running. And I think I've demonstrated my commitment not just to this job, but to Kitsap County, the city of Bremerton, the other cities of our community. And I would very, very much like your support in going forward to continue providing that support and that commitment.
Well, thank you for coming. We appreciate your time.
Okay.